to have sanctions for things such as food, light, take the light bulbs away, which is admitted.
Food has never been used as a punishment.
Appearance of Ms. Reed on behalf of the plaintiff and Mr. Schafer on behalf of defendant. This matter is before the court on the defendant's motion to change custody parenting time. And Ms. Reed has filed a answer disputing your allegations, Mr. Schafer. Anything else to add?
Well, no, I've received the answer. I guess the only thing that I would point out is that much of that which is alleged is admitted. And we've got a situation where we got a 14-year-old child who is doing well in school and sports, who for whatever reason is put under, I submit, a punishment for her basic needs based on whatever program they've got in that house. And as a result of that, she is suffering emotionally and is struggling to keep up with her schedule. To have sanctions for things such as food, light, take the light bulbs away, which is admitted, putting eviction on your room and your furniture because allegedly not following the rules. And we are submitting that the food that is available is different because of punishment. I think that needs to be changed. It's having an effect on the child. And this is the only way that we could bring that to the court's attention. We submit, in spite of the rebuttal on the answer, that efforts have been made to discuss that with the plaintiff to no avail. So I think if there is a dispute, I think there needs to be a hearing. So that's our position, Ron.
Okay, thank you. Ms. Reed, anything else other than your answer?
We rely on our answer, Your Honor. The allegations are not true. There is a chore system in place with an allowance system that goes along with it. The child has not been denied any basic needs. She did not clean the main bathroom, so she doesn't get to use the main bathroom. There are 2 other bathrooms that are available. Food has never been used as a punishment. There was a 2-hour lights out period on one occasion as part of the punishment where she probably had to go to bed early, and to make sure she went to bed earlier to follow through with the punishment, yes, the light bulbs were removed for a 2-hour period. That is not unreasonable. She could have done her homework anywhere else in the house. These are normal punishments to go along with consequences of not doing her assigned chores. We submitted the chores list to the court attached to our response. None of the chores are that unusual or ordinary. She has to clean up after dinner. She has to help cook dinners and meals. She has to clean the bathroom. She has to help essentially keep up the house and with the rest of the family. This is not singled out to her specifically, and she has to help clean the bathrooms, keep her room tidy, and help around the house. The plaintiff is teaching her responsibility in that he's teaching her how taxes work, how expenses work, and that goes into the plan of the allowance tied into the chores. Of you do your chores, you get allowance, you get fund money. You also are taught savings, you're taught expenses, and we do not believe this is like an abuse and neglect situation as the defendant's motion reads. So we're requesting that the motion be denied and that parenting time be switched to alternating weeks as the child is now a teenager, and the 2-2-3 alternating schedule that the parties are doing is causing some issues with taking extended vacations, as well as when there is ever a extended weekend during someone's parenting time according to the school schedule. We are also requesting attorney's fees.
Okay, thank you. Well, what the clerk's going to do is, as I read the petition, obviously there's a sufficient proper cause and change in circumstances alleged in the petition to meet the VARCA threshold for an evidentiary hearing. I know that is disputed, but that's why we're going to have an evidentiary hearing to make a determination in this matter. The court will reserve on attorney fees pending the outcome of that evidentiary hearing. We will be in contact with both your offices to find out when we could get those arranged, and then we will proceed. Anything else, Mr. Schafer?
Does the court wish an order based on the court's finding?
Yeah, well, if you would, just state that the court will set the matter for evidentiary hearing and will reserve on attorney fees.
All right, I will prepare that and submit it, Your Honor. Thank you.
Thank you. Ms. Reed, anything else?
No, Your Honor.
Okay, thank you. You're free to go.